Well, welcome and thank you to the February 24th, 2016 City Club program, Pot and Public Policy, Washington's Marijuana Industry. We've got two great speakers today, and it's been more than 3 years since I-502 overwhelmingly passed, legalizing and regulating the sale and use of recreational marijuana in the state of Washington. Now there are more than 300 retail outlets generating hundreds of millions of dollars in sales. And in the first year of legalization, the state collected over $70 million in tax revenue. Now, 20 months after retail recreational marijuana sales began, we'll look at the state of the industry and explore some questions with our panelists today. We're joined by the director of the Washington State Liquor and Cannabis Board, Director Rick Garza. He's going to join us up here. And Heather Wolf, a partner with the Bellingham legal firm Brownlie, Wolf & Lee. They'll each be giving a brief presentation, and following that, we'll be exploring some questions that I'll pose from the program committee members, as well as opening the questions to the floor for all of you. So today, we're going to look at the state of the industry and explore, have legal sales of recreational marijuana generated the tax revenue that the state had hoped for? What sort of compliance issues are being looked at and examined? How is the tension between medical and recreational changing as we understand the legislation and live with it? And of course, what hurdles do applicants face while trying to get into this new industry? So I want to welcome and thank folks today for giving some time to this topic. And we're going to begin with Mr. Garza, who's been the director of the Liquor and Cannabis Board since 1997 in Washington State. During his career with the board, he has also held the positions of legislative and tribal liaison and policy director and deputy director. Before joining the Liquor and Cannabis Board, Mr. Garza served 13 years as a staff member for the Washington State Legislature, including 5 years with the State Senate and 8 years with the State House. He's going to address some topics today about revenue, compliance, intergovernmental issues. So welcome, and let's get you started.
Thanks, Mary. Great to be with you today. I want you to know that I've been fueling the economy. I have a junior at Western. And 2 weeks ago, my daughter Maria was accepted, and she'll be joining Western next fall. So I have a senior and a freshman here. So I hope you enjoy the money that I've been providing you all. So I want to give, obviously, Heather and myself an opportunity to hear questions because there's so many of you, and I'm gonna fly through these slides as quickly as possible. But I feel like I need to give you some background of what we've been up to since this law passed back in 2012. It's been a few years. So key elements of the law when it passed. One, it legalized production, processing, and retailing of marijuana for adults 21 and older, decriminalized possession of 1 ounce of marijuana, 16 ounces in solid form, 72 in liquid, and little did I know that solid form, we'll talk a little bit about what that looks like, and even beverages with infused marijuana, created a 3-tier system of licensing, regulation, taxation, similar to alcohol. So real quickly, Allison Holcomb, the director of the ACLU, policy director here in Washington, wrote and authored the initiative. And what she did was she said, what is common about alcohol and marijuana, and whether people like it or not, believe it or not, they're both drugs. And so she actually wrote the law to reflect our alcohol beverage law. Many of the requirements for licensure are similar to hold a liquor license. Enforcement is very much like that. And before I forget, Tom Dixon is the captain of our enforcement region here for the Liquor Control Board. Tom grew up in Mount Vernon, I think, and actually has been in this area since I met him 19 years ago. It's always nice to have a cop close by for me, so it's nice to have Tom here. And actually, I brought him because you might have questions with respect to what does enforcement look like, what are the issues that we're seeing, and I wanted Tom to be able to share that with you. But getting back to Allison Holcomb, she built the initiative to look very similar to how we regulate alcohol in the state, and I'll be sharing more about that. So it created a 3-tier system. What is that? So that's the old law with respect to alcohol. It's very different than what they did in Colorado, Oregon, and Alaska that legalized last year, where if I'm a producer or processor, I can't have any interest, direct or indirect, in a retailer. And if I'm a retailer, I can't have interest in a producer or processor. I asked Allison, so I know that was the original intent of the alcohol law. Why did you do that? Her concern was that there would be large corporations that would control the marketplace. And so she wanted to divide those tiers so that if I was a producer or processor, I couldn't have control over the retailer. So I'll just share that briefly because there's a lot to go through here. Obviously, these were the projections that were initially made with respect to the excise tax and the forecast. So there's a fiscal impact statement that has to be written for all initiatives in the state. Back when it was written, there was so little uncertainty about how much revenue that would come in. The estimate that was made that over 5 years, $0 to $2 billion would be collected by the state. Now, everybody glommed on to $2 billion, and I always told people, remember, what the fiscal note said was $0 to $2 billion, not $2 billion. I'll share with you what that looks like. These were the original projections. I'll just share you for 2015, it was 36.3 million. We collected, in fact, 68.4 million. And then I'll share with you in a minute projections for the next 4 years. What the initiative really asked us to do, and what it did, was establish a THC bloodstream threshold for marijuana, similar to alcohol, as you know, limits on the number of store locations, advertising, the number of outlets, and then it earmarked revenues for healthcare research and education. So really what we were left to do, and basically when the initiative passed in November, we had until December 1st of the next year to write regulations. That was the requirement in the law. So we created what we believe is a 3-tier system, as I said earlier, licenses for producer, processor, and retailer. We have an enforcement arm that gains compliance with relation to those licensees, and then of course we collect and distribute taxes and fees. So here's something that happened right after the initiative, both for Washington and Colorado. We paused and we thought, well, my goodness, are we going to write regulations knowing that this violates federal law, that it's a Schedule I controlled substance? It doesn't get any worse than that. So we started writing our regulations, and then pleased to the U.S. attorneys from Western Washington and Eastern Washington to ask the federal government, specifically the Department of Justice, you have to give us guidelines. Are you going to allow us to move forward with this experiment or not? And it wasn't until August of 2013, 9 months later, that these guidelines were given to us and Colorado, and they really break up into 3 areas. And so when you think about how did we determine how we were going to write our regulations, there were 3 areas that the federal government had concerns, and I'd sum the 8 guidelines into how you're going to keep it out of the hands of kids, and I'll talk about that in a minute because, of course, you have to be 21 to purchase and consume. Number 2, how are you going to keep it out of the criminal element? How are we going to know that cartels and criminals are not going to be involved in this? And I'll talk a little bit about that. And then number 2 was how are we going to make sure that it's safe for people to consume? So we had very little knowledge of what we were getting into. In fact, we were surprised. We thought that we'd go to Europe to find out how to regulate cannabis or any kind of drug. And what did we learn when we looked to Europe? What Europe has done is decriminalize if they've done anything. They didn't create regulatory systems for licensure, for enforcement, for tax collection. They basically just decriminalized. In fact, I was surprised to learn that France is very strict with respect to cannabis and has not decriminalized. And interesting enough, when I've talked with the folks, I'll share with you, 20 states have come to Washington to sit down with us to talk about how we legalized marijuana. 7 countries have come to meet with us to talk about, share us how you put your regulations together. But in France, interesting enough, they have probably the most strict laws with respect to cannabis, and their youth have the highest consumption rates in the country. So we looked out to Botec, and actually Dr. Mark Kleinman is well known around the country and the world as an expert on marijuana policy. We worked with Dr. Bo Kilmer from the Rand Corporation, who helped us decide, because the initiative actually restricted us. We had to decide the canopy, how much we were going to grow, to make sure that we weren't diverting product out of the state. That was a real interest of the federal government. Washington and Colorado, how are you going to assure us you're not going to be diverting product out of the state or inverting illegal product into your legal marketplace. And I'll talk about how we did that, but we worked with Dr. Bo Kilmer with the RAND Corporation. They actually surveyed the counties and the cities to determine, if the best they could, what the consumption rate was for those over 21. We actually worked with Colorado. Colorado was the one state years ago that had regulated medical marijuana. So we met with them every 2 weeks. There were about 25 on their side and 25 on our side. And we conferred together to determine how we were going to both write our rules for recreational in our state and in Colorado. I talked quickly about our licensing requirements. You actually have to go through a criminal background check to hold a license as a producer, processor, and retailers, which means fingerprints, both with the Washington State Patrol, and then we have an agreement with the FBI with respect to those checks. Even those that have provide financing or investment have to go through a criminal background check. You see a 6-month residency requirement. The law actually started with a 3-month residency requirement, but the legislature, actually a legislator from Snohomish County, moved that to a 6-month residency requirement. And then in the original law, and what was very difficult for us, especially in the dense areas like Seattle, was this 1,000-foot restriction from schools, childcare centers, transit centers, game archive, libraries, playgrounds, public parks. For the most part in Seattle, it was difficult to find a place, given how dense it was, where a retailer could be located. And then in order to make sure that we weren't diverting product out of the state with respect to the licensees in the industry, we created a traceability system that they have to report, if I'm a producer, processor, or retailer, movement of that product within that premises, their sales, and I'll share a little bit more about that. That has been difficult both for us and for the industry. Packaging and labeling requirements. So obviously, as a regulator of alcohol, the federal government has regulations in place when the bottle comes to us. There are packaging and labeling requirements that are met. The fact that the feds obviously are not involved in this meant that we had to look to Colorado and others to determine the kind of packaging and labeling requirements that we would have, and I'm sharing those with you on that slide. We also have labs that have been certified by the state to test the marijuana, both by producers and by processors. I'll give you an example of some of the things that we saw when we first began. I had no idea that they made cotton candy and ice cream with infused marijuana and gummy bears. The board took a pretty strict position initially and said, they wrote an emergency rule that said nothing can be especially appealing to children. No gummy bears, no cotton candy. We had seen that that was sold in the medical unregulated marketplace here and in Colorado, so the board took a pretty strict position. I'll tell you, it can be rather subjective because what an adult likes with respect to cookies and brownies are also things that children like. So we drew the line on anything that mimicked, and you can see by the slide that there are candy bars that are mimicking that are infused with marijuana. So anything that would be, again, and it's difficult to do, determine especially appealing. We have a 4-person committee at the board that looks at all packaging, all labeling, all products. Anything, again, that looks bright colored or mimics candies aren't allowed to be sold. On the right side, that's an example of packaging that has been approved. As I said earlier, we provide that all testing must be done. There are limits with respect to signage and product warnings with respect to the stores. Just a quick recap of where we are today. We have 846 producer processors in the state, about 13 million square feet of canopy that's being grown. We have 254 licenses, 207 that have reported sales. The board a couple of months ago, as you probably heard, with the reconciliation with medical, approved another 222 stores statewide. So we'll get up to, by the end of July, is probably over 420 stores statewide. I wanted to let you see what Whatcom County looks like. You've got, I believe, 14 stores that in Whatcom County that will be approved by the end of July. At large, and then you have 6 in the city, and we'll have approval for 6 more by the end of July. Your sales, really most of the sales occur in the Bellingham area. I think there's 28 million in sales since we began in Whatcom County. 23 million of that is in the city of Bellingham. If you go to our website, you'll see a dashboard that you can go to that lets you see where our producers and processors are located and also where our retailers are located. If you hit on any of those dots, it'll tell you who they are, where they are specifically, and their address. That's something we provide to the public because we get so many questions about where the locations are. Our sales activity to date, as you can see, is around 800 million for the last 19 months. You can see what for the fiscal year, what those figures look like. We're averaging around 2.7 million in sales daily. Remember, the original fiscal note said 38 million. We actually came in at 64.9 million. We're at 103 million for this fiscal year. The estimate is that we'll hit about 164 million statewide. So the business continues to grow, and with reconciliation with medical, you'll see the revenue forecast for the next few years continues to grow. Remember, we talked about that $0 to $2 billion number for 5 years. We're estimating that it's actually going to be $1.24 billion over the next 5 years for that 5-year forecast. So ironically enough, it ends up being somewhere in the middle between 0 and 2 billion. Just so you can see what the daily growth has looked like over the years. You see a little dip there, and that happened when Oregon went legal, and some of the sales in our stores in Vancouver fell as much as 50%. But those sales have now began to grow. Oregon imposed a tax, and so it looks like that marketplace is back up and running again in the Vancouver area. The average price per gram was very high initially because the supply was low. Right now, you can buy grams in retail as low as $7 a gram, typically I think around $10 a gram. Believe it or not, the black market continues to fall, as you can imagine, because of the competition with the legal market. But we're actually a little bit surprised to see that the price per gram has fallen as much as it has. Part of it has to do with an oversupply. When those new retailers come on board in the next few months, that will change. Current challenges, I talked quickly. Obviously, conflicting with federal law is a problem. I think one of the things initially we would have rather have done was allow the marketplace to determine what the marketplace looks like rather than creating this restricted marketplace that determines that only so many people can come in to the marketplace. I know for the medical folks that have had dispensaries over the years, they're concerned that there's not going to be room for everyone to join the marketplace. We determined in looking at what the figures are. One of the things we didn't know was what is the size of the marketplace? How much of the marketplace is the legal market? How much is the medical market? And how much is the black market? BOTEC, when it looked at that, and there's a lot of critics, typically the critics are the folks that are worried they're not going to get a license in the state. What BOTEC found, what they believe is that 37% of the marketplace is the legal marketplace, 35% is medical, and 28%, hope that adds up, 28% is the black market. So what we did initially, knowing that we had over 240 stores licensed statewide, we just doubled the number to 222 for the new marketplace in the next few months. And so we'll likely have over 400 retailers statewide at a market that looks like around 800 million for this fiscal year. So I'm just going to throw this figure out because people say, well, that's just not enough retailers. Seattle was concerned that they didn't get enough retailers. Remember back in 2011, the state ran the spirits business. That spirits business, the last year, was $940 million in sales for the state. $940 million in sales for the state. We'll take the city of Seattle as an example. How many retail outlets did we have in the city of Seattle, liquor stores? We had 21. And that served the entire city plus all the bars and restaurants, right? Seattle will have 48 retail locations by July to serve a marketplace that's much smaller than the marketplace that we had for spirits. So we looked at those figures. The original estimate of 335 was based upon the number of state and and contract stores that the state ran when we were in the spirits business. That's why we decided we'll start there and we'll increase the marketplace as we need to. But lots of folks have asked, how did you get to the figure that you are? And so for those areas that don't have bans and moratorias, we basically double the number of retail outlets that are available in your city or county. We continue to have issues with respect to banking. How do you keep the criminal element out of it if you don't allow people to use financial services? Unlike Colorado, we've had less issues with respect to that. We have 4 regional credit unions that are providing banking for our retailers. That's about 67% of them are using it. Some are choosing not to do that, which is of concern. But we continue to work with the banking industry to make that available. And then obviously with respect to advertising, you're always balancing that with free speech. Obviously, one of the concerns the state have is that we have a lot of bans and moratorias around the state, basically in eastern Washington, basically in those areas where the majority voted no. That continues to occur. People often ask us, and I'll go to a lot of smaller communities that voted no, and you know, they do have the right to determine to do that. I don't think there's any less cannabis in those communities, whether they're legal or illegal. I think that's the balance of all of this. 44% of the population voted no in some communities around the state. It was a big no. They choose to continue, many of them, to live under the ban and moratoria. I'll share with you that when you think about the revenue that's being collected, it's probably going to be about $160 million. A lot of that's going to go to the local economy with the B&O tax and the retail sales tax. That's money that those communities aren't getting because they choose to live under a ban and moratoria, and they certainly have the right to do that. But I share with them, don't think just because it's not legal that it's not in your community. It's obviously in every community as far as cities and counties. But again, we leave that up to the local jurisdictions to determine when they want to move forward or not. I talked a little bit about marijuana-infused products. I'm not going to go into that because I don't want to cut off the time. Looking ahead, very quickly, with the reconciliation that the legislature did through Senate Bill 5052 for medical, really the system created this merit system that basically said if you had a medical dispensary and you can prove that before January 1st of 2013, just about right after the law passed, the new law, then you would have preference. So many of the people that are going to be holding the new retail license, the vast majority of them have been medical dispensaries. And people have asked the question, well, what about the patients? Are they going to have access to the product that they want? 70% of over the 200 stores that we have licensed today have said that they're interested in holding a medical endorsement. All of those that are getting the new retail licenses that were medical dispensaries obviously have an interest in selling medical. So in effect, 85% of the over 400 retailers that we have will be selling also medical product. We'll talk a little bit about the tribal compacts. There was a bill that authorized tribes to be able to get into the business. I could cover that later. There's a great article that was done by the Brookings Institute. It was a fellow, Philip Womack. It was August of 2014. He actually looked at Colorado and Washington comprehensively. What are the systems that they put in place? Take a look at that. I think it's the best that's out there with respect to, it's pretty long. Looking at both the referendum in Colorado, the initiative in Washington, the strengths and the weaknesses of both systems, I think it's the best thing that's out there. So thank you.
Thank you. I want to introduce you to our second presenter, Ms. Heather Wolf. Heather is a partner with the law firm of Brownlie, Wolf & Lee. She's been practicing real estate, land use, and business law in Bellingham since 1997. Currently, her practice is primarily devoted to advising marijuana business clients in Whatcom County and throughout Washington state. She regularly posts articles relating to the marijuana business issues on her website and has written an ebook on the topic, Turning Green to Gold, Tips on Starting a New Legal Marijuana Business. When she's not advising marijuana businesses, Heather can be found mountain biking or trail running on Galbraith Mountain. And Heather's going to address topics regarding hurdles license holders and applicants are facing, intergovernmental issues, some issues that you may want to tackle, and some of the tensions between the medical and recreational world as this is merging. Thank you.
Hi, thank you everyone for coming. I got into this area in 2012 when I-502 passed. My existing clients came to me and wanted to know how to start marijuana businesses in Whatcom County. And so since that time, I've been working with marijuana businesses in Washington State, and it's pretty much taken over my practice. The director gave us some numbers, and I just wanted to just show you what the landscape looks like in Whatcom County. We have quite a number of licensees. 37 producers, 41 processors, 14 active retailers. And what you can also see up there is there are still a lot of pending license applications. Whether those will be issued or terminated, we'll see. But our corner of the state does have a lot of licensees. So what I'm focusing on today are the biggest hurdles that my clients face. So most of my clients are marijuana licensees, but I do have some people still in the application phase. Illegality under federal law. That is probably the biggest issue for marijuana licensees. And the director talked a little bit about how we function even under federal illegality. So I'm not going to repeat the federal enforcement priorities. But there are some distinct issues that my clients face. Number one is probably banking. I'm sure you're all aware that this is a cash industry. Well, it really is, because you can't, like any other business, you can't go to your local bank or a national bank and open up a bank account. There are only a couple credit unions that actually accept accounts for marijuana businesses, and those credit unions are very selective. It's hard to get into them. So most of my clients, they're operating on a cash basis. And yes, there are grocery bags full of cash traveling around. And it's a big problem. And unfortunately, I don't see any solution for that anytime soon. So if banks aren't opening bank accounts, they're also not lending money to marijuana businesses. So that's a big problem. You can't get a line of credit as a marijuana business. So when you're looking to start a business, your source of funds are very limited to private financing. So what that means as a practical matter, my clients have to get money from friends, family, or the few private lenders out there in this state that can lend to them. Another big problem that businesses face is the federal taxation issue. Under IRS Section 280E, all marijuana businesses know that section, they cannot take any federal tax deductions or exemptions. And that's because under federal tax law, if you are operating a business that involves illegal drugs, and marijuana is still illegal on the federal level, you can't take any tax deductions. So these businesses are paying a lot of tax. They're paying a lot more tax than any other type of business. And so they're paying a lot of tax, they've got a lot of cost, and they can't declare bankruptcy if things go really bad. There is no bankruptcy protection for these marijuana businesses. There have been a number of federal court cases on this. You cannot declare bankruptcy. So there's really no debtor relief for these businesses. There are some other federal issues that I think probably don't come to people's mind when they think about this business, but there's no federal intellectual property protection. So what that means is you cannot file for a federal trademark or patent with regard to any marijuana product or even marijuana-related product. So that's a branding issue, because a lot of marijuana businesses want to be able to protect their brand. Now, they can do so in state, but there's no ability on the national level for people to protect their brand. I also wanted to just bring up the risks for landlords. So tenants, marijuana business tenants need a landlord. But being a landlord for a marijuana tenant has its own risks. And that is because most people who own property have a mortgage on that property. And virtually all mortgage or loan documents state that a property owner cannot use their property for any illegal use, including a use that's federally illegal. So if that property owner with a mortgage leases to a marijuana business, they could technically be in default of their mortgage. So they risk a loan default or a foreclosure. And what that means for marijuana business tenants is generally that risk is passed on to them in the form of higher rent. So it's an issue both for landlords and tenants. Something that we talk to a lot about with our clients is contract enforceability. So we are fundamentally a business law firm, and we prepare business contracts for marijuana businesses like we would for any other business. We do leases, partnership agreements, loan documents. But the difference for our marijuana clients is there's uncertainty about whether they can go enforce these contracts in a court of law. I mean, we know they can't go to a federal court. We know they probably can't cross state lines. But even in Washington state courts, it's a bit unclear as to the ability of state courts to enforce contracts that are illegal under federal law. So it's a gray area. We have had success locally in enforcing marijuana contracts, but it is of concern. So getting away from the federal impediments, I think the biggest issue at the state level for applicants is the state residency requirement. And the director touched on this, but anyone who applies for a marijuana license has to demonstrate that they resided in Washington state for 6 months prior to that license application. This is also true for their spouse. So that's a big issue for folks. If your spouse lives in California, you can't apply for a Washington marijuana license. Same thing for managers of the marijuana business. You have to demonstrate that they have been Washington residents also. What I find people get hung up with is that business owners who apply for a marijuana license also have to be residents. So if someone has an LLC, marijuana LLC, and they are applying for a production license, every member of that LLC and every spouse of that member of the LLC has to be a Washington resident. Same thing for corporate shareholders. So if Marijuana Corp applies for a marijuana license, every shareholder has to be a Washington resident and their spouse. Financiers. So anyone who provides money currently to a marijuana business has to be a Washington resident. So it's currently in-state funding only, and that also holds true for any financier's spouse. Now, I think the state has recognized that this is a big problem. There is such limited ability to get financing because you can't go to a bank and get a loan, that the state has actually proposed a rule change that would allow out-of-state financing. So it would remove the residency requirement for financiers. Now, you still could not have an ownership interest if you're out of state. So that limits things, because that means you can only loan money. You can't take an equity interest in the business. There was actually a bill proposed in the legislature that would allow non-resident ownership of the business. It would allow out-of-state folks to have a minority ownership interest in the business. I don't think that bill is going anywhere, but I think that may portend something for the future. I think that if you're going to allow out-of-state lending, you probably need to allow out-of-state ownership, because I think most lenders want to take an equity stake in the business. Otherwise there's no security for these lenders. A lot of my time as a land use attorney is helping clients find suitable marijuana business locations. There is only one limitation from the state on where you can locate, and the director touched on this. This is the 1,000-foot limitation. The purpose is to keep marijuana out of the hands of minors. So a business can't locate within 1,000 feet of a school, playground, library, transit center, game arcade. But again, the state recognized that this was a big deal. It is really hard to find a location that meets zoning requirements and is not within 1,000 feet of a playground or school or game arcade or library. So last year, they actually allowed jurisdictions to reduce the 1,000-foot buffer to 100 feet, except in regard to schools and playgrounds. And I had an interesting case in Bellingham. I represented a retail store that was about a week away from getting its license issued, and a game arcade located just down the street from it. And so fortunately we were able to work with the city of Bellingham because this bill had passed, and they were able to reduce the 1,000-foot buffer to 100 feet because fortunately at that time the city was renewing its marijuana ordinance. So we worked with them, and now in Bellingham that buffer is reduced to 100 feet except for schools and playgrounds. It's very difficult to find a location because there's lots of places in Washington where you just cannot locate a marijuana business. Our count was 88 cities and 8 counties, and that's a lot of locations that are just completely off limits. And even in those cities and counties that allow these businesses to locate, every city and county has its own unique set of zoning and building restrictions. And I included a couple examples so you could just see how everyone has taken a different approach to this. Bellingham is really straightforward. What Bellingham has said is that producers and processors can locate in an industrial zone, and retailers can locate in an industrial zone or a commercial zone. So that straightforward makes sense. Now, if you go outside of Bellingham into unincorporated Whatcom County, it's different. You can't, a marijuana business cannot be located within 1,000 feet of a community center. That means church. And guess what? There's a lot of churches in unincorporated Whatcom County. The facility also cannot be located within 300 feet of a residence unless all the owners of that residential property sign a written waiver. And in the rural zone, marijuana facilities, production and processing facilities have to get an administrative use permit. And what that means is they have to give written notice to everyone within 1,000 feet. And everyone within 1,000 feet gets to comment, and those comments have to be responded to by staff and the applicant. Skagit County, I wanted to include that because you can see there are very few locations. There's a lot of X's on that chart where you can locate a marijuana business, and they have completely prohibited outdoor growing in Skagit County. In most places, you have to be located in an opaque building. You cannot locate in a translucent greenhouse. So, you know, when I talk to people about applying for a license, I don't feel that getting through the state application is the hard part. It's really meeting all the local requirements. So the first thing I ask people when they come to me to talk about the licensing process is, have you looked at the zoning requirements for the jurisdiction where you want to locate? Because if you're not in the right zone or you can't meet the setback requirements, then you need to look elsewhere. The second thing that I advise people to do is to get a building permit. And the reason is that jurisdictions continue to change and revisit their marijuana zoning. And if you don't get a building permit, you are not safe from any zoning changes. And if you don't get a building permit, but you have a state marijuana license, if the next week that county prohibits marijuana businesses, you can't operate. It does not matter that you have a state license. Local zoning trumps. I did just want to touch on the medical marijuana industry. That's been a big challenge for my recreational clients. I mean, basically, they were and are competing with a untaxed, unlicensed industry. I think the passage of the Cannabis Patient Protection Act helps. The dispensaries and collective gardens have to stop operating by July 1st of this year. They have to come into the 502 system. So I think that's a good thing. It'll be interesting to see what the actual demand is for medical marijuana once that changes. And new retail licenses are being issued. Applications were being started being accepted in October, and the overall cap for retail stores is going to be raised to 556 stores. So I think just to conclude, I think a few things need to happen to grow the legal marijuana industry. And one of those is increased access to funding sources. So I think allowing out-of-state investment is needed, and hopefully that rule will be approved. And there probably has to be some consideration of some out-of-state ownership. We've got to come up with some banking alternatives. And one solution to that may be the tribes. People have been talking about the tribes operating financing institutions for the marijuana industry. To the extent that we can encourage jurisdictions to lift their moratoria, that would be a good thing. It's really difficult for this industry to succeed if you have half the cities and cities and counties in Washington state banning these facilities. I think it is, as the director said, it's naive to think that marijuana sales are not going to happen even if you don't allow these businesses to operate. And we need a level playing field to compete with the black market, and that's only going to happen if cities and counties treat these businesses like they would other businesses. And so similarly, I think there needs to be a relaxation of overly stringent zoning requirements. Thank you.
Thank you. So before we take questions from City Club members, we've got some folks that are going to come around with mics to take your questions. So if you're a member and you have a question, you're going to need to stand up, and someone will approach you and offer you a microphone to ask your question, and we'll get you a chance to speak with the presenters that way. Briefly, we did have a couple of questions from the program committee, one that came up right away, and this one's for Rick. We understood the intergovernmental issues according to this industry, and we're wondering, we see on your website the LCB accepts tax payments in cash at its headquarters, and we're wondering, do you have many businesses who remit their tax payments in cash?
Too many.
Too many, thank you.
I think that's part of I mean, we're much better off than Colorado in that at least we have 4 regional banks, credit unions that allow for retailers. We're hoping that the Washington State Employees Credit Union, which is statewide, was going to begin a pilot on February 1st, but they've backed off a little bit. I think that continues to be an issue. What we know is that many of the folks in the business, not just retailers, had bank accounts with banks and continue to use those banks. So that's something that's kind of under the radar, not so much anymore. But I think that's a problem. It's actually smaller than we had thought it would be. But we continue to work with those folks to go ahead and use. I think for some of them, they actually don't want to pay the banking fees associated with it. And it's like you need to join the real world here. If you're going to be involved in a business, you need to use financial or banking services that are available to you. But I will say, Mary, it's smaller than what we worried about initially.
And Heather, I'm wondering if you could speak to any kind of enforcement or compliance issues you see happening from your client perspective. We've heard some from the state's point of view.
You know, it's early days, and so many licensees are just trying to get up and running. And I'm not just saying this to curry favor with Rick, but I think the LCB agents and investigators have been really good to work with. I think the licensees are learning and the investigators are learning, and they have been helpful. I think they want to see the industry succeed, so they're really good about working with the licensees.
And to follow up, you mentioned and described some of the incentives and disincentives for investors who might want to become participants in this emerging market. I'm wondering what the investor mix looks like in terms of institutional investors relative to private. Are you seeing?
I don't see any institutional investors. It's all private lending. It really is friends and family. A lot of times there are private, I guess, venture capitalists out there, but so many of the people that we deal with, it's just people that they know who are getting involved.
Thank you. So, questions from the floor. We've got one over here. Yes, if you stand, a mic will come to you. We'll start here in the back, and Chuck will bring one over. Go ahead.
Yeah, Terry Borneman. For Heather, one, the city hasn't changed the law to 100 feet. That hasn't been done. We're still operating under basically the same restriction under emergency regulations. Some of it could be changed coming forward. So that didn't happen. But my question is, when you're talking about lifting moratoriums on different jurisdictions, do you think it might help if the state released the tax dollars that were supposed to come to local jurisdictions, which they have refused to release, that would help make up the minds of other jurisdictions to want to get involved with the tax revenues?
I think any carrot we can throw at the cities and counties would be good.
Maybe the approach of the legislature was to use a stick to what you just said, which is, as long as you continue to work under a banner moratoria, we will not share money with you. If you lift your banner moratoria, then we will. I mean, that's what I saw that happened.
I'm Steve Giordano. I have two questions. One, it may be too soon to tell if underage marijuana users, has the number increased or decreased? And the second question is there a way to characterize people who are interested in going into the business, growers, retailers, processors? I mean, I know what I think of a real estate agent or a plumber or a dentist, but I don't know what to think. I don't know anybody in the marijuana business.
So at the invitation of folks who feel comfortable to self-identify as involved in the current industry, this is what some of your community looks like. Thank you for joining us today.
So there's a healthy use survey that's done out in our schools, if you're familiar with that, where certain grades are asked questions, and marijuana's been one of the questions they've been asking for years, along with alcohol. What we've seen so far, as alcohol use is down, it's been flat with respect to marijuana. Those in the prevention and health community and treatment community are concerned with the issue of normalizing. In other words, their fear is that by making this legal for adults over 21, the same thing that happened with alcohol, which it becomes more permissive with respect to youth. I don't know the answer to that. We're going to find out, because we're going to continue over the years to be able to see whether in fact that happened, that youth are going to be more likely to consume now that it's legal for adults than when it was illegal. You know, I think you can argue that one back and forth on both sides. My own son told me, Dad, it's easier to get pot than there is alcohol before this thing became legal. Now that's anecdotal, and it's one person. But it's certainly not difficult to get marijuana when it was illegal, obviously not today, now that it's legal. But we haven't seen anything in the healthy use survey results of the last 2 years since it became legal that suggests that there's a spike in use. But honestly, I can't imagine that there isn't some increase.
Thank you. We've got a question back here from Jane. Go ahead.
So this question could be for either one of you. What is the latest information, or do you know about what the federal government is saying about moving marijuana off the Tier 1 schedule? And if that happens, would that change the banking piece of it as we currently know it?
Well, yeah, I mean, if that happens, that will change everything. So I think there's talk about it by certain congressmen and some presidential candidates. I don't know if there's any serious effort being made to deschedule marijuana.
There have been efforts by Congresswoman Del Bene, Congressman Heck, who's been working and helping us with respect to the banking issue. To what Heather just said, if it's brought down, that helps. I think what you're going to see is California has it on the ballot, I believe. It's the 7th largest economy in the world, which I didn't know. 90% of the marijuana that's grown in California is exported out of the state. As more states legalize, and you're seeing it on the West Coast and you're seeing it on the Northeast Coast, the South has a different opinion of it. Though there are over 25 states that have medical marijuana laws to some extent, some very restrictive. In Georgia, for example, it's very restrictive. But you're seeing change. I think it happens over time. When that happens and when other states legalize, it allows, and I don't know if that's good or bad for this state, for us to open the marketplace to allow more people in. Because one of the concerns I think that I would have as the regulator is the inability to bring people into the marketplace and allow the marketplace to determine those, because we will continue to have a black market until those that want to be in the market can be in the marketplace, and that means to me 3, 4, 5 years before this is settled.
Okay. We've got another question up front here.
Okay.
Thanks for your patience, sir.
With the various varieties of pot, for edible pot and liquid types of pot, CBD and THC quantities are always well listed and documented and very carefully. I had a question about smokable or vaporized pot. Is among the varieties of those, is there some way that you can know how much the percent of THC and CBD in them, according to the state?
No, we can. That's required on the package and labeling. I'll share with you something that I saw a couple months ago in looking at the different forms that it's provided, whether that's flower and bud, whether that's an infused or an edible, whether that's through cartridges and vaping or the other terms that I don't know well enough. 75% of the sales in the state is bud and flower. That's predominantly what's being sold in the retail outlets, even though there's great interest, obviously, in the edibles and the infused and the other forms of consuming the product. But for this state, so you know, the vast majority of it is bud and flower.
Another question?
Good afternoon. I'm Pinky Vargas. I serve on Bellingham City Council, and I also serve on the Tourism Commission. Something that was recently brought to me by the hoteliers is right now the only place that people can smoke pot is in their home. And obviously, in regards to tourism, people want to enhance our economy by bringing tourists here, and are wondering about legislation that is going to change things that will allow people to smoke pot in public places or in designated places like Amsterdam coffee shops, etc. And I'm wondering if there's any movement on that to go from just private consumption into public places.
Well, remember what I just said with respect to how people are choosing to consume, and we have a Clean Air Act in the state, or I can't consume marijuana if I'm smoking it or tobacco in a public place today. There were a couple of bills that were introduced to allow for cafe and lounges where people could consume, but the big question is, so what am I going to do in that cafe or lounge? Am I going to eat a cookie? How am I going to consume it legally? I mean, it's just a practical question, and maybe the industry can tell us how that's going to happen. But if in fact the reason, and one of the bills in the Senate, the impetus for it was people are smoking marijuana outside all throughout Seattle, for example. They say that's not true, but to some extent. How does the cafe or lounge deal with that issue if people are choosing to continue to smoke marijuana when you can't smoke in a public place? So I'm not sure how that's going to be remedied unless they're consuming it in another way. So I think it makes sense that in the future that would be allowed, but I don't see how the practical impact of it. 75% of people are smoking bud and flower and you can't smoke in a public place. How's that going to happen?
As I've heard all this today, my thought is, and I don't know the answer, is any of that money being designated for research, scientific research into the effects on long-term use for the human body? Is any of that money being used to maybe have task force to try and get a handle on why our culture is in such a state that we have to zone out? And is there any designation for this pot of money, or is it just going to go into the general fund?
So if you go to our website, you'll see what the original distribution of the revenue was. And if you look at what Allison Holcomb did, I think it was only 13% that was supposed to go to the general fund. The rest of it was prevention, treatment. The universities, UW and WSU, were given money. Even the Public Institute, the Institute for Public Policy at the Evergreen State College was given funding, and a report was provided last September. Didn't say a lot because this is fairly new. But there is an effort in the original intent of the legislation to look specifically at education through the Department of Health, and then treatment and prevention. BHR through the Department of Social and Health Services was given sizable amounts of money for treatment and prevention. So there's an effort to do that. Believe it or not, 50% of the revenues in the initial initiative was for the basic health care plan in the state. And then we had the federal law that intervened, and much of that money went to the state, and they used it to the point that the gentleman just raised. But the original intent of the law or the initiative as written was to put money in those areas to look at some of the issues that you raised, which I don't know how you answer the question of the abuse of a drug and the impact that that has on a community. And I think, I'll say this about Allison Holcomb, if you ever get a chance to have her come here and talk to you about how she wrote the initiative and why. She's not afraid to look at the implications of the policy as written. What impact does it have on the community? If you go back to why she sponsored the initiative, it was really to deal with the social and criminal justice issues with respect that those were involved in the criminality of the industry and of the product. That was really the motivating factor with respect to her. But I think, unlike Colorado and some of the other states, there's an effort to put money to find out whether this is a correct policy moving forward. And you'll all be able to decide that in the next few years as you see what happens.
What's your last name again?
Holcomb?
Heather, do you have anything to add to that?
No, I think the director handled that.
Oh, quit calling me that. It's Rick.
Sorry, Rick. Rick handled that.
Feeling old now.
Okay, we've got a question here from the back.
I'm Peggy Parker, and I just wanted to say that this is really an interesting exchange, excellent exchange, and thank Mr. Garza and Ms. Wolf for coming here. You've answered all my questions but one, and that was, what was, if you know, the tax rate in Oregon?
I want to say it's 20%. Does anybody in the industry know? We're at 37.
Yeah, I think 20 is
I
right.
have a question here.
I have a question, sort of a technical one that I think our growers and especially distributors may be interested in. Given the ambiguities of federal law and some of the problems in state law, what happens if there's a dispensary and one of the 1,000-foot limitation entities moves into their area? Who takes precedence, and how would they defend that legally?
Well, if the retail store has been issued a license, that they are protected from a child care center or another similar entity moving in. Now, the situation I had, the license was not yet issued. And there tends to be a big lag time. Someone applies for a license, but it takes time to build a facility, get the local permits, get the inspection done, and the license to be issued. So that licensee is not protected between the time it applies for a license and the license is issued.
So typically, like a liquor license, they're grandfathered in. So if I, for example, have a restaurant that serves alcohol 500 feet, or a school comes in 500 feet from that, that would not apply. So the idea here is that that business is protected because it was there before the other entity came in that's maybe within 1,000 feet.
Okay, we've got a question here and time for one more after that.
I'm not sure if either of you will be able to answer this, but when the law was initially brought forth, there was concern that the driving under the influence aspects of the regulation were kind of onerous and not very accurate in terms of actually people being affected. Do you know if that's been clarified any or what the status of that is?
Tom, you want to talk a little bit about what we're seeing out there with respect to DUIs? Knew there was a reason I brought him.
Thank you. Tom Dixon. I'm a captain with the Enforcement Division. We do not currently enforce DUIs, but I have regular discussions with the Washington State Patrol. I know that alcohol-related fatalities are up. We don't exactly know why. But we're currently in the situation where the state has transitioned over from a new breath test system. That company that owns that breath test system is very protective of their information, and Washington State is a very big public records state. In other words, if you want to see anything with regard to public records, you could probably get it. So this company that has this new breath test machine doesn't want to give up their proprietary information. So it's made it very difficult in courts to prove those DUIs using that new instrument in some counties. So that said, DUI, when a law enforcement agency processes a DUI, they almost entirely have to get a search warrant for blood, take the blood, have it tested. And they test it for alcohol and for marijuana and some other drugs as well. So because it's so much more work, we're seeing the number of DUIs statewide go down significantly.
Thank you for that great question. And we are at 1:30, so I need to take this moment to thank our guest speakers, Mr. Garza and Ms. Wolf.